What is going on, BriHive? Welcome back to yet another live stream. Today, we have some pretty juicy cases, one of which that we're going to catch up on, and another of which that is brand new in the Love is Blind era. We love the reality shows. So we have a new lawsuit against Netflix for Love is Blind. For those of you who do not know what Love is Blind is, it is a reality TV show where people go into these strange pods to meet the love of their lives, and they fall in love without ever seeing each other, and then they get engaged, and then they spend like a month together. And then they have to get married at the end of the month, or they can decide that they don't want to get married. And one of the contestants is actually suing Netflix. Heck, there's a couple of contestants that's actually suing Netflix, but this is a brand new one that just came out. I intend on trying to find the other one that's going on right now as well, basically alleging that they're not taking care of their contestants. And then we have an update on Tom Girardi, the attorney that got disbarred last year, that's married to Erica Jane. He is found competent to stand trial. If y'all know Tom Girardi, please go ahead and comment in the chat and let me know whether you think that this finding was fair or not before we actually jump into the documents, because I didn't know which way they were going to lean. But I am happy that they lean towards the competence, and the shade that is in the prosecution's briefs are ridiculous. Like, y'all, I'm not even going to lie to you. I didn't have time to read the defense's whole brief. It was just too long, too boring, too technical, right? But the shade in the prosecutor's brief, I was like, okay, this is juicy. I got to read it all the way to the end. I didn't finish their reply to the defense's reply because I didn't have time. I had to eat dinner. But the first one we're going to read all the way through. I tried to find like different sections to go through to show y'all, but it's too much. It's too much attacking in there for us to skip a single sentence in there. So if you guys are watching live, make sure you go ahead and hit the like button on your way in. It helps us out in the algorithm, y'all. And we have been doing pretty good with our views, and also pretty good with our likes on the live stream, and also pretty good with our viewers during the live stream. That has been pretty exciting. So if you haven't already, please do hit the like button. It does help us get more friends over here in the BriHive. Y'all, I am working on coming up with catchy taglines, so wait for it. They'll be here. I got to test it out, test the waters. Maybe I'll put it in a poll to see which one you guys like, and I got to say it out loud so y'all can hear it. But anyways, if you're watching live, go ahead and drop it in the chat. Let us know where you're watching from, or just say hello if that's what you wish to do. If you're watching on the replay, go ahead and drop in the comment section that you are watching on the replay. I am trying to get better at responding to those comments, so hopefully I do see them. I don't know. I just am lazy sometimes and I don't respond. I do it all the time to my little sisters. Every time I go on Instagram, there's like 4 or 5 messages just from my little sister of her trying to send me reels, and I just don't. It's so bad. I have to get better at it. I just respond to them all at one time instead of as she sends them to me. But I think her limit is like 4. And then after 4, she doesn't send anymore. Let me check. She might have sent more this time, but after 4, she just stops. Oh no, this one says 4+. So actually, she sends more than 4. She beat her record, but I haven't checked it in like a week. So it's so bad. It's so bad. I promise I will do better. Okay. Let me see who's watching live. We have Mary Jane, really not Sarah, dropping a B. I hope you are here live still. That was from 648. She asked me when I was going live earlier. Cardova82, hello and welcome into the live stream again, saying good evening to the BriHive and to the Queen Bri when she shows up. I was a couple minutes late. Not that bad, right? Okay, like 5 minutes late, but hello and welcome back into the live stream. We have Crystal Harris giving us the eyes, like, where am I at? Yeah, I was a little late. I had to eat dinner. And my husband decided he was going to cook something new. And he was like trying to be perfect chef. And I was like, okay, when are you gonna be done? I gotta eat. Okay. Cardova82 says, hi there to Miss Crystal Harris. Good evening. Crystal Harris says, good evening. Oh, Tanya D, member and moderator of the channel, saying happy Thursday, everyone. Hello and welcome into the live stream. Nice to see you tonight. We got some juicy tea going on. Or is the buzz like trademark? I don't think it is. Can we call our tea the buzz? What's the buzz? Is that weird? Let me know in the chat. Let me know if that's weird in the chat. I like it. I do like it. Okay. Then we got Kimmy Locker saying hello, BriHive, dropping a B emoji. Don't forget to like on your way in. Of course, we got Kimmy, our moderator, our paralegal of the channel, what else is she? Our consultant of the channel. And she is also backstage and in the live. There's one thing that I'm missing. Member and moderator of the channel. Okay, that is it. And then the paralegal and the consultant. Welcome in, Kimmy. Nice to see you tonight. Cardova82 says, well, hello to Tanya D and Kimmy Locker. Mary Jane says, LOL, still here. I fell asleep, but you woke me up. Woke me when you came on. Okay, good. We got you here. And it's okay if you fall asleep, just as long as you're here in spirit, right? Good to see you, everyone. Crystal Harris saying good job to husband. Yes, of course. It was delicious, spicy, but delicious. It was soup because I am still sick. And I feel like I don't sound like I'm that sick, but I'm hoping I can make it through because before we got on here, I was coughing like crazy. So hopefully I can get through all the talking without losing my voice or coughing or whatever it is. Nissa Howard says, you're not as late as Rob is sometimes. Yeah, I try to be pretty much on time. The thing is my live streams are already late and I don't want to make them any later. I actually want to get to a point where I can make it earlier so that we can have more friends here with us live. Z Seltzer says, here, BriHive with the waving pink hand. Hello and welcome into the live stream. Nice to see you. Another member of the channel. 20th Century Fox says, hi from Cape Cod. Hello and welcome into the live stream. Where is Cape Cod? Y'all know I don't know geography. Welcome in, dropping the B emoji. Love to see it. Happy to have you here. Okay, that was hello to everyone. So next, we are going to go ahead and jump right into Girardi because it is a long case. For those of you who do not know the Girardi case, it is Tom Girardi. He was a pretty popular lawyer. He did personal injury. He dealt with like catastrophic injuries, including I think it was the Lion flight that crashed a couple years ago. And a lot of the people from there, they did not get their money. So they decided they were going to sue him. They still couldn't get the money. Oh gosh, I just got rid of my share screen. Get it together, Bri. Oh wait, I forgot to show our pet. I don't have it together today. Let's show our pet in a moment. Where are we at? Come on, Pat B. Okay, so say hello to our pet B. Tom Girardi, he's a California lawyer who makes us do like this stupid extra step on our bar license now. So I have to go. I forgot. They sent me the notification to do my trust account thing because thank you, Tom Girardi, for messing it up for all of us and making us do an extra step for our bar license. But he represented catastrophic injury clients. He won millions of dollars for his clients, but he also was not paying his clients. He was borrowing a lot of money from litigation banks. I forget what they call them, but they like loan out money so that people can go to litigation and you're supposed to pay them back after you win your trial. He wasn't paying them back, okay? And then he was borrowing from some like schemy ones, and then he just wasn't giving his clients their money, or he was robbing Peter to pay Paul. When this lawsuit was done, he paid people from like 8 lawsuits ago, and then you got the other 7 still waiting. It was a lot of little funky things going on, and he just was not giving his clients their money from their personal injury lawsuits. And so they decided to sue, and he filed bankruptcy, and his wife is Erica Jane, who is the Real Housewives of Beverly Hills, which is why I know of Tom Girardi. I don't know if you guys know him from just being a popular attorney. I know lawyer personalities on TV was not like really a big thing back then, but maybe you know him for whatever other reason. He was a very popular attorney in the Los Angeles area. But I know him because Erica Jane in Real Housewives of Beverly Hills. And she got dismissed from quite a few of the lawsuits. But this is a criminal case where he's being charged with wire fraud on several counts and then criminal forfeiture, I believe, on one count. But anyways, he wasn't giving people their money. He was robbing Peter to pay Paul, and that's the wire fraud. I don't know what the actual criminal forfeiture is. So I might have to look into that. Oh, yes. Kimmy just said it might be worth noting that it's for wire fraud. Yes, it's wire fraud and then criminal forfeiture, but I don't know what the criminal forfeiture is. So now I want to find it so that we can make sure we understand what's going on. And the wire fraud is mostly like embezzlement, not taking their money, paying himself, buying Erica Girardi allegedly, or I guess not allegedly because they told her she had to pay it back at this point, $750,000 canary yellow earrings or yellow earrings. I don't know, diamond earrings that were yellow. He was just doing all kinds of stuff. Like, I'm just flipping through this and it's just embezzlement of client funds. Okay, forfeiture allegations. Let's see what the forfeiture is. Wasn't planning on going over this, but let's make sure we're on the right page here. So I don't want to be little in the corner like that. I would like to be, where would I like to be on my screen? I want to be up here. Okay. So let's see here. Forfeiture. Pursuant to Rule 32.2 Federal Rules, notice is hereby given that the United States of America will seek forfeiture as part of any sentence pursuant to this code in the event that defendant Thomas Vincent Girardi and or his co-defendant or his defendant Christopher Kamoon, that is a strange name. I think I'm probably saying that wrong. But in the event that Tom Girardi's conviction and of the offense set forth in the counts 1 through 5 of this indictment, any defendant so convicted shall forfeit to the United States the following: all right, title, and interest to any and all property, real or personal, constituting or derived from any proceeds traceable to the offense. Oh, so they want his stuff. So he stole money, so he's not able to keep his stuff. I don't know if we need to read any further. Let's go ahead and go into B, though. To the extent such property is not available for forfeiture, a sum of money equal to the total value of the property. Oh, do they want to keep it themselves or give it to the victims? Interesting. Now we know what criminal forfeiture is. He does not get to keep any of the stuff that he got from stealing money from other people. Okay. Let's get into the shady government's post-hearing brief of for order finding defendant Tom Girardi competent to stand trial. And y'all, we were not able to pull the order because it is filed under seal. But Kimmy did let me know that the attorneys have 5 days. I don't know from what date. Kimmy, if you can remind us, 5 days to determine what should be under seal and what should not be under seal, what's private, basically. So hopefully they don't go and put these briefs under seal because they do talk about the medical information. We also did have a assessment checklist. I don't know if we're going to go through that because that was like 20 pages, and I don't think I have the bandwidth to do that right now with my stuffy nose. So let's get right into the government's post-hearing brief. For order finding defendant Tom V. Girardi competent to stand trial. Go ahead and drop in the chat. And Kimmy, if you can, make a poll whether the chat thinks that Girardi is faking his incompetence. Remember, it was that he had dementia, and then it was Alzheimer's, and we're gonna get into this in the brief, and then it was just a mild deficiency, So, do you guys think that he's playing this up? Do you guys think that he's really losing his memory, or do you think that he or I guess those were the two options. Is he really losing his memory? Does he have dementia? Is he faking it to get out of the charges? I mean, he's been stealing money for years. Do we really think that he cannot fake an illness? Do we really think that? I don't think so. I think he can fake an illness, but I don't have a race in the horse, okay? We're just talking about the facts, okay? At the BriHive in the live in the BriHive, okay? Plaintiff, the United States of America, basically asked the court to find that Tom Girardi is competent to stand trial. They are basing this on files that they received from the final transcript of the competency hearing that was 3 days long, in compliance with the court order. Or where is it? Where was that? The testimony and exhibits introduced during the 3-day competency hearing, files and records of the case, and any such evidence that the court is willing to admit in the case. So that's what they're basing this complaint full of shade on. Let's get into the introduction for the memorandum of points and authorities. Defendant Thomas Vincent Girardi is competent to stand trial. Unrebutted evidence presented during the 3-day competency hearing confirmed the information provided in the pre-hearing briefing. Both demonstrated that in the months and weeks leading up to his precipitous purported decline, defendant was continuing to practice law, communicate with clients, negotiate with lenders, and manage his law firm, which handled hundreds of active matters that he oversaw. Although the court heard lay witness testimony about defendant's occasional forgetfulness and disorientation, and the government's own expert diagnosed him with mild cognitive impairment, mere cognitive decline is not the standard in determining whether defendant is presently competent to stand trial. Rather, the court need only determine by a preponderance of the evidence whether he currently has a rational or factual understanding of the proceedings against him and is able to consult with his counsel with a reasonable degree of rational understanding. The government has met that standard. The testimony at the evidentiary hearing not only failed to undercut the government showing, it often supported it. So basically saying they proved their burden and the defense did not defend. That's basically what they're saying there. The government presented testimony from two experts, Dr. Diana Goldstein and Dr. Ryan Darby, who each opined that the defendant was presently competent. Their opinions were based in part on defendant's medical records, neurocognitive testing, collateral interviews, and importantly, their own interaction and observations of defendant. Each opined that defendant was exaggerating the extent of his condition, and each identified material inconsistencies in his clinical presentation. So he was basically acting. So like they come up with these tests to determine like if you really have something wrong with you. And they can tell when you're acting or you're trying too hard to basically be this impaired person or just trying to get diagnosed with something, maybe trying to get some meds. They deal with this every day. And these doctors are saying he was faking. So I'm going to jump into y'all chats in a minute to see whether y'all also think that he was faking so far. Let's get back into it. Far from an unawareness of this case or an inability to form new memories, defendants tracked the allegations against him, offered a variety of excuses for his criminal conduct, and discussed matters that only recently transpired. He further described rationally and specifically how he would defend himself against such allegations. So he's saying that he is not competent to stand trial, but if I do go to trial, I'm going to say I don't know nothing. It's basically what he's saying. Defense counsel, on the other hand, proffered only one expert, Dr. Stacy Wood, who claimed that defendant was incompetent. However, Dr. Wood admitted that she failed to consider contemporaneous evidence of defendant's cognitive function leading up to his claimed incompetency. Evidence that directly contradicts the trajectory of his claimed impairment. Throughout these proceedings, defendant has exhibited an understanding of the criminal charges in the case and the ability to meaningfully confer with his counsel. I don't like how that they wrote that. They put confer too many times, in my opinion. I don't know. Am I tripping? If he so chooses. Accordingly, the court should find him competent. So they basically just called him a faker. They basically called him a faker all throughout it, and that their expert is no good, basically. She basically said, oh, yes, he's incompetent now, but the fact that he was like on a podcast 2 weeks ago, 2 weeks prior to him becoming incompetent, that doesn't matter. Although I think it's a slow decline, that part doesn't matter. It's not going to work, okay? Let's see. Cheryl C says the whole Girardi story is wild. It went on for decades, and even the CA bar members were involved. Exactly. And the CA bar kind of got out of it and saying, well, the people that let him slide no longer work for the California bar, so we can't do anything. But now we're going to implement all of these new things. It's annoying, right? And now he doesn't have to deal with what he has presented for us. 20th Century Fox says, yes, CA Bar basically allowed it. Corruption is coming to an end. I hope as it's hard to hide anymore. Yeah, and everything's on the internet. You got people like us on YouTube talking analyzing things and breaking it down for people to understand and bringing awareness for it, because this was not really happening a lot back in the day. Z Seltzer says death faking. Okay, no one's on his side so far. Mary Jane says even if he's not, he's still been stealing before the dementia, right? But he has to be able to defend his stealing before the dementia. But you are absolutely right. You're absolutely right. He was still stealing. We just gonna forget that he steals because he has dementia just because he forgot? Like, no, that's not right. Oh, love it. 20th Century Fox says maybe both. Don't we have to have a doctor's note on this? And that they talk to doctors, but both sides are gonna say the doctors were incompetent. So which one do we really believe, right? Or is it going to be his behavior on the stand, or is it going to be his behavior and having an excuse for what he did? He has to understand that when we'll go through the standard, but he has to understand the charges against him. His charges are embezzlement. Embezzlement is stealing. And he goes, I didn't steal anything. So he clearly, maybe not the best understanding, but he does understand what he's being accused of. If he can tell us he didn't do it, then he knows what he's being accused of. Stealing. What is stealing? Taken from other people. We're going to get into it, but also maybe all of his clients didn't receive all the money that they were entitled to, but it wasn't me, is what he's saying. So I think the judge got it right in the competency, but we'll get through at least the prosecution's brief. I'll summarize what I went through on the defendant's brief, because I'm not going to lie to y'all. I didn't finish it. It was too technical. It made my brain hurt, and I had to eat my ramen. Okay. So yeah, we're going to get into it. He fakes it until you're accusing him of something, is the way that I took this brief. Mary Jane says, I think you can see dementia in an MRI, so they should test him. They're saying they did test him. So we'll go through it. 20th Century Fox says, yep, faker. It's Tom Girardi. There's no slack for you over here. I'm sorry, man. And they're going to talk about him cussing on the stand, but it's not a lot. Yeah, I'm sorry. My nose is all stuffy now because I'm talking. Okay, let's jump back into it. I'm trying to like bookmark and do everything. So it's easier for the edits, or not edits, but putting timestamps. Did y'all see that I put timestamps for y'all on the last video? Took some time, but we have some timestamps. I'm going to work on the other ones. Okay, let's see here. Argument. Defendant has been malingering since late 2020. What is malingering? They're going to tell us in a minute. The question of defendant's competency is large part hinges on whether he is fiending and or exaggerating the extent of his condition. Any purposeful efforts by defendant to manipulate these proceedings and make himself look more impaired than he truly is would certainly demonstrate his appreciation of this criminal matter and its potential consequences and exceed the low threshold of establishing competency. Accordingly, as defendant's own expert conceded, when tasked with evaluating an individual's competence, one must be critical of the claimed symptoms and scrutinize them. This is especially true in criminal cases where defendants are incentivized to fiend the extent of their impairment. Nonetheless, neither defense expert critically examined defendants' purported symptoms. As an initial matter, Dr. Chu readily conceded that she was not asked to conduct a competency evaluation, nor does she have any expertise in the field. So they presented a doctor who is basically his primary care physician that didn't even check whether he was competent. This is a competency hearing. Why is she here? Why is she here? She further admitted that she has never conducted a forensic evaluation before, nor does she have any forensic evaluation training. And while Dr. Wood purportedly conducted a forensic evaluation, she conceded during cross-examination that she both failed to consider relevant evidence of defendant's malingering and in some cases failed to adequately explain or even acknowledge his inconsistent presentation. So basically, while he was being examined, his behavior changed. One second he was incompetent, other second he was probably normal, right? Evidence of defendant's intellectual malingering from December 2020, when he first claimed incompetency in connection with the Lion Air civil matter, is relevant to an evaluation of defendant's current competence. That is, if defendant were exaggerating his impairments in 2020, but claiming, among other things, that he did not appreciate the allegations against him, then his identical claim in 2023 may likewise be exaggerated. However, when repeatedly asked whether she considered defendant's previous claims of incompetence, Dr. Wood claimed they were not relevant to her evaluation. She did not ask for any evidence of defendant's capabilities in 2020 because she believed it was not relevant for her focus on the current cognitive abilities. The defense or the prosecution wants them to consider, is he faking? He was fine in 2020, and then all of a sudden when 2021 hit, he was no longer fine. Right? Can it happen that fast is what they're asking. And she's basically like, it's not relevant to me right now. He's not competent at this moment. For example, when presented with defendant's voicemail and letters from 2020, Dr. Wood conceded that defendant's capability at that time were inconsistent with his claims of incompetence. Let's see. Question: Is that significant to you? Does that tend to contradict that claim? Answer: yes, potentially. Would you agree that it is inconsistent with that claim? Answer: it does seem to be. Okay. Although admitted from her report, Dr. Wood admitted during cross-examination that defendant was probably not incompetent in 2020. And that he was likely suffering from MCI rather than dementia. I think that's mild cognitive impairment. Yeah, mild cognitive impairment. Dr. Wood's failure to consider this relevant evidence of malingering undercuts the accuracy and reliability of her opinion. Dr. Wood further failed to acknowledge defendant's inconsistent clinical presentation both in her expert report and during her testimony. When confronted with defendant's purported lack of memory that he had a third wife and his incongruent statements about past United States wars and presidents, Dr. Wood refused to consider that they may represent efforts to intentionally manipulate the proceedings. For example, Dr. Woods blamed such inconsistent presentation on frontal lobe atrophy. However, she acknowledged that defendant's most recent brain scans place him in the 70th percentile for frontal lobe volume, well above average. So his frontal lobe is fine at this point. Dr. Wood further admitted that despite defendant's incongruous answer regarding historical facts, such as incorrect statements regarding past presidents and wars, I would probably mess those answers up too, Tom. I'm not mad at you. These facts are not short-term memories that are typically affected in the beginning stages of dementia. She ultimately conceded that his responses were unusual. Again, I probably would get those answers wrong because why am I counting presidents? I don't know. But he's also a lot older than me, so he should probably know more presidents than me from like experience, if that makes sense. Furthermore, because he's an adult experience. Furthermore, Dr. Chu admitted that she did not conduct any tests for malingering. When she evaluated defendant, she likewise did not consider defendant's capability in late 2020 For example, his role as a moderator at a live stream panel discussion regarding the law at which he was a featured guest, but admitted that such information would be relevant to a determination of defendant's mental abilities at the time he first raised the claim of incompetence. So he's fine one moment and then not fine at another moment. Dr. Chu also failed to consider the suspicious timing of defendant's claims of incompetence starting in December 2020. Indeed, her role as defendant's treating physician presented a conflict with her instant assignment. As a treating physician, she took an oath to help her patients and act in their best interest, which she readily conceded was different from a forensic evaluation. Her lack of any effort to determine whether the defendant was feigning or exaggerating symptoms of cognitive dysfunction, or indeed to question whether defendant could be exaggerated or feigning impairment, thus cast doubt on her reliability and accuracy of her opinion. Both Wood and Chu also put significant weight on collateral interviews rife with incomplete information. For example, Dr. Chu relied on defendant's daughter, Jennifer Crane, who was estranged from her father. Dr. Chu testified that a reliable collateral informant is someone who knows the patient well and is familiar with the symptoms and context in which they are occurring. Despite alleging that defendant's purported memory decline began in 2017, by her own admission, Ms. Crane had not seen defendant in over 14 years and only reconnected with him 2 months prior to the time of defendant's legal trouble had already surfaced. So basically, she gives a definition that in order to be a good lay witness, you have to know the person. His daughter said she hadn't seen him in 14 years and recently just, got back into a relationship with him when she found out about his needing to go into a conservatorship, which indicates that she doesn't know enough about him. She hasn't been around him enough in order to really make that determination for us. So let's see, where else are we at? They also interviewed Miss Munoz, who was a program coordinator at the Sunrise Senior Living Facility. Let's see. For example, Ms. Munoz testified that neither she nor the staff spent that much time with the defendant. In fact, Ms. Munoz only see him occasionally when he stops by her office, and his care manager spends maybe about an hour a day with him. Moreover, Ms. Munoz testified that staff from defendant's previous senior living facility were confused about why his family was escalating his level of care given his independence. So he was independent enough to care for himself to the point where his previous senior living facility was like, why are you doing that? And basically passed him off to this other senior living facility where they might baby him a little bit more or not really acknowledge the fact that he has a lot of independence. Indeed, for the past 2 years, defendant has been at the lowest care level in at Sunrise. There's 1 out of 5, and he's at the lowest level because he's pretty independent, which reflects near total independence with need for minimal reminder, a fact that Dr. Chu conceded is significant. So if he has dementia, he probably would need a lot of reminders compared to not a lot of reminders. As for defendant's recent drastic decline, Ms. Munoz testifies this began shortly after his indictment in this matter. Timing that is both highly suspect and inconsistent with Dr. Chu's opinion that defendant's illness is slowly progressing. So not only is he able to function on his own pretty much in his care facility, but they're also claiming that his decline is slow, but he's showing us a quicker decline as well. So a lot of the things are basically kind of contradicting themselves as they go on. And the evidence presented during the competency hearing demonstrates that defendant has been intentionally exaggerating his impairment since 2020. His claims of being unaware of his criminal and civil exposures, which have persisted until present day, are demonstrably false and evince his cunningness and thus his competency to proceed. And y'all, the thing is that he's being accused of stealing money. Are we really going to believe that he's not shiesty enough, for lack of a better legal term, to then fake his competency, especially given his age? He's like, I can get away with this. Like, I can literally get away with this, which sucks because there's people that's actually suffering from the illness and he's just playing around with it at this point. And he's going to be highly, highly upset if he ends up actually getting the dementia, if he doesn't really have it compared to what the prosecutors are alleging. Okay, let's get back into it. Neither party disputes that defendant is an 84-year-old. An 84-year-old exhibits some of cognitive impairment. However, the mere presence of a mental disease or defect is not sufficient to render a defendant incompetent. Let me see. Incompetency to stand trial is not defined in terms of mental illness, and a defendant can be incompetent to stand trial despite being mentally ill, or similarly, a defendant can be found incompetent to stand trial without being mentally ill. So basically, they have to understand the charges against them. It's a very, very, very low threshold. It is by preponderance of evidence. And the way that we describe it when we talk about it in family law, it's like putting a feather on a scale. And if it tips it just a little bit, then that is preponderance of the evidence. So it's definitely not beyond a reasonable doubt, not more likely than not, anything of that nature. It is the easiest standard to overcome, and basically he understands his charges as they're going to describe next. Okay. So each of the defendant's clinical interviews in connection with this proceeding demonstrated his understanding of the charges against him. During interviews with the government experts, defendant accurately recalled that he was accused of not paying clients, a fact discussed earlier in the meeting, and then related at several points over the 3-day examination without prompting that he did not do anything wrong, did not steal from clients, and he did not steal from clients. Likewise, in his interview with Dr. Darby, despite disclaiming knowledge of the indictment, he said he didn't even know there was an indictment. Defendant frequently told Dr. Darby that he did not steal anything, echoing his comments to Dr. Goldstein. Remember, those are the two doctors from the prosecution side. While acknowledging that Girardi's clients may not have received all of the funds to which they were entitled. Even the defense expert, Dr. Wood, conceded that notwithstanding defendant's claims to the contrary, she believes he actually does have an appreciation for the criminal charges against him. So his own expert witness said that he understands or has an appreciation for the charges against him. He knows what he's being charged with, and that's what the law requires. Defendant also has the capacity to consult meaningfully and rationally with his counsel if he chooses to do so. Indeed, defendant outlined his defense strategy for the experts, strategies that Dr. Woods considered were rational and sound, which is the defense's expert witness, Tom's expert witness. The court further observed defendant's ability to process information firsthand when he hurled an expletive under his breath at prosecutors. So he's in there being rude. He was in there probably like, you freaking loser, leave me alone. He probably said a lot worse words than loser, but you guys get the point, right? Such examples highlight defendant's true ability to track and process information in real time and understand the significance of that information. Other evidence further corroborated this assessment of defendant's cognitive abilities. I'm gonna pause right there. If y'all haven't already hit the like button, please do. But also, there is a poll in the chat, if you're watching live, asking, do you think Tom Girardi is faking incompetency to avoid facing trial? Answers yes, no, and I don't know. We're going to go over the answer at the end of this brief, which is almost done. So make sure if you haven't voted yet, please do vote. There are only 14 votes, but 25 people watching live. So make sure you get your vote in if you would like to be not considered, but if you would like to contribute to the vote. Okay. Where am I at? Such examples. Other evidence further corroborated this assessment of defendant's cognitive abilities. For example, Dr. Wood conceded that except for some faucet of memory, defendant's remaining cognitive domains were relatively normal and in some cases above average. This includes his attention, processing speed, executive functioning, and even working memory, which was a relative strength. And while defendant's brain scans show abnormal hippocampal atrophy, the defense experts agree his atrophy dates back to at least 2017, and thus during the time when the atrophy was present, defendant still functioned normally up until 2020, which by no means that it can't get worse for him to function. So I don't know why I guess you have to make the points, but I don't think that proves that he couldn't have got worse, although the same atrophy was there. A trophy. I don't know how to say that. Let me see. In 2020, when allegations for his misappropriation were made to the public, he basically started to have this decline once he was charged, or once the information started coming out. Accordingly, the evidence presented at the competency hearing demonstrated that defendant clearly has a rational and factual understanding of the charges against him, and that he has the capacity to consult meaningfully with his attorneys if he so chooses. His instance of being unaware of his legal situation is willful and deliberate. He can opt to participate meaningfully in these proceedings at any time. Conclusion: for the foregoing reasons, we ask you to find Tom Girardi competent to stand trial, basically, is what that says. Okay. Like I said, we're not going to actually read through the defenses because it's long. Because it's long, basically. Okay, I didn't download the defense's response. Where was the defense's? Okay, here we go. It's long, and it's like how a lot of this one was attacking the doctor's understanding of what's going on. There's talk a lot about the doctor. I didn't even make it into the part about whether he understands or not. Okay, I'm gonna go ahead and check the chat. So let's go ahead and. All right. And so let's see. We have the poll. Do you think that Tom Girardi is faking incompetency to avoid facing trial? The chat says 75% yes, 10% no, and 15% I don't know. Because do we really truly know? I think that he's definitely skilled enough in his deceit to be faking the incompetency. When he first pulled out the fact that he was incompetent, he wasn't incompetent when he was funding his wife's trips. I agree with that. I definitely understand that you can become incompetent. Maybe you never really expect it to come, but him and his cunning history is why I believe that he's faking it. Now, if he just had like a pretty normal life throughout his whole life, maybe he lied here and there, but stealing people's money constantly, that's more than lying here and there, right? So I do think that he's faking it. I think he's trying to drag it out. He's trying to avoid trial for sure. That's my opinion. We have Mary Jane saying, what happens if they find him incompetent? Is there no trial? Will he be put in some care home? Basically, the trial would be delayed until he is able to stand trial. So he would have to be tested again. But my boy has enough money to keep dragging this thing out. He'll basically be put in a care home, mental home, somewhere where they can assist with him until he's competent to stand trial. If he really has dementia and he never becomes competent to stand trial, then he just stays there without facing any prison time. They'll never really get a judgment against him, which would suck for the victims that were, harmed by him. Kimmy Locker says to Mary Jane, he was found competent, but if he had been found incompetent or declines to a level of incompetency, the trial can't move forward. I believe he's already in a home, though. Yeah, he's already in a senior living home, but as far as the competency goes, they could put him in a different kind of home, or they could leave him in the senior care home. But he is currently in a senior care home, but as we just read, he's at the lowest level. He is on the more independent side of the scale rather than the more extreme case of the scale. And the fact that he's able to say he didn't do anything, he didn't steal any money, I think he does understand the charges against him, and he's too smart. Even if it is dementia, he's too smart and he knows what is happening. He does know what's happening. Is he going to remember every single penny that he stole? No. But does anybody remember that, right? So I don't think it's going to work for him on that one. Cardova 82 says the bar for competence to stand trial usually is quite low. Exactly, yeah. You just need to be able to understand the process and be able to assist in your defense. Am I right, Queen? Yes, you are absolutely right. It's the put the feather on the scale. It goes down a teensy weensy bit. That is enough. You are competent to stand trial. Right. Crystal Harris says 84. Yes, he is 84. Tiny D coming with the speech language, the speech lesson at trophy. Is it at trophy? At trophy. I don't know how to call it a trophy. I don't even know. We're not a speech class over here, and my nose is stuffy, so we blame it on that. That's okay. Let me see here. Where's my little our buddy here? Yes. So let's get into the defense. I have some notes on that. So let me actually pull up my little notes on it because it was long and I am not going to read through that for you. I can barely breathe now. So we're not going to read through it. Okay. So the defense, they get to reply to the government's request for the court to find him incompetent. And they go ahead and respond. And the reason why I didn't like their response, it was like so technical. Maybe we'll look at some of it, but it was so technical. They first start off by saying that the United States experts are not reliable. That's the same thing that the United States did as well, right? They said that the defense's experts are not reliable. And then they went on to why they weren't reliable. But then they also went on to explain why their experts were reliable. The defense, on the other hand, and maybe they did later on in the document, but like I said, I didn't read the whole thing. So I am a little bit biased. If you guys want to read the document, let me read it for yourself. Let me know. We have it. We can share it with you, okay? But they say they're unreliable. They argue that Darby was not competent to testify or as an expert because he basically became a doctor 2 years ago and he's only practiced really with his brother and like one other psychiatrist. And so we shouldn't really be listening to what he has to say. They also talked about how when they asked him about certain tests, he didn't really know the standard, didn't really understand it, couldn't really apply it, right? And then we get to Goldstein, who they call not an expert because they said that she did not have any experience or barely any experience in geropsychology. Geropsychology is the psychology of older adults. But they ignore the fact that she has done the test several times for maybe people that were not necessarily old. The United States point out that they don't know whether there is they don't know of any rule saying that you only have to evaluate older people in order to be an expert in the field, although you have expertise in the field of analyzing people's brains, whether they're young or old. They also accused her of improperly doing the test because she let like some sort of, I can't remember exactly what the title was, but some sort of assistant in her office do the test. She basically didn't watch this assistant do the test. And then basically that Girardi failed below the threshold that Goldstein was ranking her at, or they were basically like ignoring certain numbers. I didn't like it. I could not focus on it. Like, I can't even read it to you guys because it's so jumbly that I was just confused the whole time. But we can see if they ever got into anything outside of the doctors. Let me see. How far did I get into this? I got pretty far into it. Okay. Yeah. So it's still too long for me to really get into. We still have to get to Love is Blind. So if you guys want to see it for yourself, let me know. But basically they just said your freaking witnesses suck. Your witnesses suck, and that's why you cannot win. But they ignore, and maybe they do get into it a little bit in theirs. Let's see. Okay, let's say they say he has long years of decline. So let's actually read some of theirs. So we did a summary of, okay, this one's only like one paragraph. Okay. So the defense also presented extensive, uncontroverted, contemporaneous records confirming Girardi's decline. In January 2021, which is after all of these things started coming out, Girardi reported a burglary at his residence. Officers from the Pasadena Police Department responded multiple times to investigate. Although they were focused on the burglary, the officers noticed Girardi's cognitive impairment. Similarly, the day after Christmas 2020, again, after the time that all of this stuff started coming out. Give me some times before that. Girardi woke up screaming he could not hear, and the Wrangler rushed him to urgent care. There, Girardi reported being unable to hear and denied having recent injuries or procedures. After inspection, medical staff found hearing aids stuck in both ear canals. Girardi did not just forget that he inserted hearing aids, he forgot he even had them. The defense also submitted records from the Sunrise Living Facility beginning in August 2023. Girardi has been upgraded to care level 2, so not the lowest, but almost the lowest. Girardi now requires supervision because although he's able to maintain a facade of being oriented, memory deficits are seen over time. Most notably, he now requires standby assistance for all showering and bathing needs. But does that mean he doesn't understand his charges? I don't know. I don't know. I don't think so. So it looks like they do talk about the fact that their what do you call it? Experts are valid, but I'm not going to go through that. It was too boring to me. So we're not going to do it. Okay, let me go back. So that is on the defense. Let's go back. All right, let's see what the chat's saying. What do you guys think so far? 20th Century Fox says, do you know if he's in a fancy paid for facility or a regular Medicare type facility for us bus stop people? I believe he is in a fancy one. It's called like Sunrise Elder Living Facility or something like that. And they basically upgraded his care from his previous living facility. So I'm going to assume, and y'all can fact check me, I'm assuming that it's a fancy one. 20th Century Fox says, I know he isn't a yacht. He isn't on a yacht, but still, I wonder where he is. We can look it up. The defense is grasping at straws as is their job. It's still fascinating. Yeah, and definitely you guys can read it for yourself. They do tend to focus on, okay, this test says you have to fall within these numbers. So he fell in those numbers. Why do you not think he's incompetent? The prosecution said there is mild impairment here. There is mild impairment. They're not denying that. However, the standard is not whether or not there's mild impairment. The standard is, do you understand the charges that are being brought against you? Do you understand the words that are coming out of my mouth? That's what the standard is. It's not, okay, I forget things here and there. Like I said, you're not going to remember every single penny that you stole. And the defense is basically like, look at all of these statistics and these numbers, and this is normally what someone who has these impairments will fall into. Why are you guys ignoring that? Because he cussed us out in the middle of the trial, sir. He knew I was getting on his nerves, and not saying that people with impairments cannot understand when someone is getting on their nerves, but he's processing things at a rate that he is going to be able to participate in the trial. Does he know? And even if he was not impaired, would the partner at the law firm know exactly where every penny in the law firm went? No, I'm pretty sure they have an accounting section, right? We've read about it in the indictment that they have an accounting section. So no, he doesn't know of everything. Does he know whether he gave his wife an American Express card, allegedly, quote unquote, or not quote unquote, but gave his wife an American Express card? He should know that, but like he said here, he forgot he had a whole third wife. So he might get up there and say, "No, I don't even have an American Express card." It's just whether the jury is going to believe him. And I don't know. I don't think he's incompetent. Is his memory probably declining? Heck, my memory is declining, right? Maybe not to the level of his, but I forget things too. But I'm pretty sure if I did a crime, they're not going to find me incompetent, just like you, Mr. Tom Girardi, that's making us do extra trust reporting requirements after you get kicked out of the bar. Okay? Anyways, let's go. Let's go back to it. So, yeah, what was that question? The defense is grasping at straws. Yes, I agree that they're grasping at straws. They're trying to focus on all of these numbers, which could, be valid. I don't know, but I feel like these type of tests that they're talking about is like PVT and this test and this test and this acronym. I feel like those are sliding scales, and depending on who does the evaluation, they can get different numbers and they can interpret it different. I believe it was the prosecution's experts that said while he may have fallen into the range on the actual scale test, sure, maybe he fell into that range, but his actions outside of the test, which is what the court is going to look at, the court doesn't understand the PVT and this test and that test, right? They're looking at his actual behavior. Does he understand what's going on, despite the fact that he may qualify for dementia? Despite the fact that, like they said, you don't need a mental illness in order not to be competent, and you don't not need a mental illness, or you can have a mental illness and still be competent, and you can have no mental illness and still be found incompetent. So he failed at his thing. And even if he does have some type of impairment, which both sides seem to admit that he does have some type of impairment, the court is finding that he's still competent to stand trial. 20th Century Fox says, can he help in his own defense mentally? Sure, but the facts seem like they cannot be defended. The thing is he's going to say he don't know. He's going to say that he doesn't remember. And like I said, even if he didn't have any impairment, does he know exactly where every penny went? Does he know every time Erica Jane swiped a credit card to the business? No, he wouldn't know that, right? Or I guess he could, but he probably doesn't, right? Agreed. It's frustrating. Kimmy Walker says to 20th Century Fox says, yeah, I'm a staunch believer in innocent until proven guilty, but it seems like it's a pretty open and shut case to me. And that's why he's trying to avoid it, because he's already losing in all of these bankruptcy cases, right? He's already being put on the stand. I believe he's already been put on the stand. The allegations have already come out, and he's already losing civilly. So how easy do you think it's going to be to find him criminally liable with all of these records of the civil liability, right? Or maybe he hasn't testified yet, because that would be, he has the right to his first Fifth Amendment protections. I could be wrong. Maybe he hasn't been on the stand yet. Okay, let's, where are we at? Then we're going to get into the prosecution, and y'all, I probably read 2 or 3 paragraphs out of this one, so this is probably not going to be long. So let's. Okay. The prosecution responds and basically is like, they're grasping at straws, like 21st Century Fox said. They're grasping at straws. They're pointing out all of these invalid points about our experts. They don't really focus on the fact that Girardi is competent to stand trial. Let's go ahead. I'm not going to go through everything that they're saying. They're basically what I just argued. I argued their points is you're relying on all of these numbers and ignoring the fact that it's a sliding scale. But let's get into the stuff we actually can understand. Okay. Understand, which is even if he does have dementia, he's competent to stand trial. Okay. So let's see what they say about that. There is no agreement. Here we go. There is no agreement amongst the testifying experts regarding the true diagnosis of defendant's mental condition. In any event, a competency evaluation does not hinge on such diagnosis. Although defendant attempts to conflate dementia and competency, the two are not mutually exclusive. Although they're not mutually exclusive? I thought you would want to say they are mutually exclusive. Although medical professionals properly determine whether a defendant has a disorder or is malingering, competency is a legal concept. And even if the expert's medical conclusion of impaired ability are credited, the judge must independently decide if the particular defendant was legally capable of reasonable consultation with his attorney and able to rationally and factually comprehend the proceedings. Thus, even if defendant has dementia, this court can and should still find him competent based on the facts before it. Indeed, numerous courts have found defendants suffering from dementia and other neurocognitive disorders competent to proceed to trial. Finding an 80-year-old defendant with Parkinson's disease and cognitive impairment to be competent due to malingering. Finding a defendant of brain hemorrhage and previous dementia diagnosis competent. All right. Any other one? Finding a defendant with dementia and memory issues found competent. Defendant with alleged dementia and evidence of malingering found competent. And defendant with memory issues, alleged dementia, and evidence of malingering found competent. So basically, they're finding all of these people with the same issues that defendant is claiming, that Tom Girardi is claiming competent to stand trial. So why is he any different from these defendants? Even if this court took defendant's test score at face value, it still shows average performance. It still shows relatively average performance in most domains. And while defendant claims to have trouble with forming new memories, despite multiple examples to the contrary, even Dr. Wood testified that an individual with mild to moderate dementia can still retain new information with repetition. Moreover, when questioned about whether such tactics could be used with the defendant again, Dr. Wood testified that it could be helpful to use that strategy. Accordingly, even the defense expert agrees that repetition, cueing, and other strategies can be used with defendants to assist him in this case. While the government maintains that such assistance is unnecessary, given his clear ability to track the proceedings in real time, it is nonetheless amenable to such aids during further proceedings. So even if he has dementia and he needs things to be repeated, they can basically take the trial slow so that he can be repeated things, which sounds brutal to go through, to have to make your proceeding longer. And they asked for the court to find them competent again. They also argued that defendant's presentation, including compelling inconsistencies during clinical evaluations, support a finding of competency. I think I wrote things wrong in here. It should be incompetency, right? Defendant's presentation, including compelling inconsistencies during clinical evaluations, support a finding. I feel like that should be incompetency. But anyways, yes. Let's go ahead and jump back into the chat and see what the people are thinking. All right. There I go back into it. 20th Century Fox says, I think Bravo's evidence is enough for me. Exactly which evidence are you talking about there? Cheryl C says, in my opinion, he is just trying to drag this out indefinitely, and then hopefully he gets old enough to where he just passes away and he never has to deal with these criminal charges. That's what I feel like is happening. I agree with you, Cheryl C. I definitely agree with you there. Tanya D says, I think so too, to Cheryl C. Yeah. Because basically, if he can prove that he's incompetent, the trial stops. It doesn't go forward. But as we know from the title of the live stream, the court did find that he was competent to stand trial. And unfortunately, we don't have the order, but The court did find that he's competent to stand trial. Hopefully the order will be released in the next couple of days so that we can see what the court actually considered in making their ruling. But for now, I'm thinking that the court considered his actions, his behavior, his ability to basically say he didn't do it and he's not responsible for it, to find that he is competent. I don't think that the court gave as much weight on the medical evidence. I don't think that's the we know that's not the threshold question. Do you understand it? I think he understands it, and I think he understands it enough to know that if he can show that he's incompetent, then he doesn't have to go to trial. He can drag this out. He doesn't have to give his money up, forfeiture, right? So he's going to continue to do this until he can basically die and get away with it. And the court's not letting him do that. And they're going to present evidence. Whether Tom Girardi remembers, they're going to present all their bank records. They're going to, how did your wife get this card? I don't know. You're going to say your wife's a stealer, like that she steals things? Erica Jane, are you stealing things? No? Okay. Well, are you going to testify? She probably doesn't have to testify, though, because she was his wife. Ooh, wife at the time. There's two different spouse protections, and y'all know I'm not a criminal attorney. I'm just remembering things from law school, so don't quote me. Two different spousal protections is either while you're married, there's a protection for while you're married and you heard things, and then there's a protection if you're married and he like told you things or you heard things. So I think she would be protected under that part of the law. Sure. Oh, I think I already got that one. Got that one too. Hello, Swanky, aka Smalls. Welcome into the live stream saying, hey, it's the Buddy Bee. It's Buddy the Bee. Buddy the Bee is here and here to stay at this point. I feel like it's going to have to last. Even if I'm doing this for like 30 years. Well, I don't know if I'll be on YouTube for 30 years, but the bee has to stay as long as it can. Okay, y'all, let's get into the juicy love. Let me know what y'all thought about Tom Girardi all the way. Let me know what y'all thought about Tom Girardi. We're going to get into the love. Love is Blind. And y'all, I did not have time to look at this complaint before coming on live stream. But you know what we're going to do? We're going to read the facts and we're going to read the causes of action. And I don't know if y'all can tell, but I am getting stuffy and it's hard for me to talk right now. So we probably don't have that much longer on the live stream. I'm sorry. I know you're going to miss me, but it's okay. It's okay. No, let's talk about Love is Blind. We have Renee Poche. I think her name is Poche, right? Poche. I don't know how you say her. How do you say her last name? Renee Poche, she is suing Delirium TV, who is the maker of the show Love is Blind, which is on Netflix. So they're also suing Netflix. And let me tell y'all, if you go on the Los Angeles County court website and you look up cases against Netflix, crazy. It's like a complaint coming every month, multiple times a month. Someone is always suing Netflix. I know their legal team is big. I actually thought about joining Netflix's legal team when I was in law school. A lot of the people that went to our school actually worked for Netflix. And so I don't know what that says about my school, and I don't know what that says about Netflix, but we had like 7 people working for Netflix in the legal department. So don't know what that says about us. But Love is Blind is being sued again. There are other lawsuits going on against Love is Blind, but I haven't had time to pull those ones. We're going to go on the one that just popped up in the news today. I don't really remember Renee like that. She's the girl on the thumbnail. Because they didn't really air her portion of the experiment. And y'all, the actual agreement that they sign is attached to this. I'm not going to have time to go through that today. But what I want to do is read through it and potentially do a separate video on it. And also, y'all, we are not going to cover the Hershey's case. I thought that one was going to be a hit. Y'all did not want to hear the Hershey's case today. But that's okay. It's okay that we didn't want to hear the Hershey's case today. I will probably do a pre-recorded video on the Hershey's case because I want to know about it. I want to know why they're. I'll tell you a little bit about it. She's suing the Halloween package candy because it didn't have carve outs in the pumpkins. So I think it's very interesting. It has pretty pictures, and I think I'm gonna still cover it, but maybe on a pre-recorded video. And then also maybe Netflix's contract. I would love to see a Netflix contract, and we have one here. So I may do that one on a pre-recorded too. If nothing interesting comes out next week, then we'll cover it live. So let's go ahead and see what is going on in this complaint. Okay, we have Renee Poche. We're gonna just call her Poche. That's probably not how you say it, but let's call her Poche. Versus Delirium TV and Netflix, a complaint in the county of the Superior Court of California in the county of Los Angeles, where all the famous trials go. A violation of California government code numbers, another violation of the California Labor Code, violation of the California Civil Code, unfair competition, intentional infliction of emotional distress, and declaratory relief. Make a ruling that they did me wrong, basically, and that I can talk about the things, even though the contract says I cannot talk about the things. So let's introduce it. Poche seeks judicial relief from an sorry, y'all. I'm struggling here. Okay. Let's try it again. Poche, I want to call her Poche, but we're just going to call her Poche. Poche seeks judicial relief from an overreaching and unlawful talent agreement purporting to govern her appearance on Love is Blind, an unscripted program produced by Delirium and aired on Netflix. The state of California has an expressly stated and fundamental public policy against contracts that force employees to preemptively release intentional torts and Fair Employment and Housing Act violations as conditions of employment and that gag them from speaking about unlawful conditions in the workplace. The agreement contains numerous unlawful provisions, and Poche seeks a judicial declaration that the agreement as a whole, or at least certain provisions therein, violates public policy and is illegal and unenforceable. When she joined the program, Poche was told that all participants would be extensively screened through a rigorous background check process, psychological examination, and a compatibility assessment. Little did Poche know that she would be matched with a walking red flag. How? I thought you picked your match. How are you going to say she was matched? Well, maybe she's going to spill some tea about what's going on. Okay. And I forgot to mention that she has already been sued in arbitration because they're saying that she's breaching her contract by speaking out and doing interviews and things like that, talking about her time on the show. So they are already going through arbitration, and she's like, no, court, help me. The arbitration is going bad. They're gonna, find me liable probably. And this contract is unconscionable. It should be unenforceable, right? So let's go into it. She did what? Walking red flag. Okay. Little did Poche know that she would be matched with a walking red flag, an individual named Carter Wall. She about to go in on Carter, who was unemployed. Why are they always unemployed on these shows? Who was unemployed with a negative balance in his bank account, homeless, violent, estranged from his family, and actively addicted to drugs and alcohol? What? That's wild to say. Wall's erratic and alarming behavior and emotional instability became glaringly obvious to Poche and the production staff. Poche became utterly terrified to be around him and made her misgivings clear to production. Indeed, production had its own concerns about Wall, warning Poche to ensure he did not have access to firearms and other weapons. Nonetheless, Poche was forced to spend long stretches of time alone with him. I thought it was real and you got to pick your love. They matched the people up. Delirium made it clear that she would subject herself to legal action if she were to discontinue her participation in the program or otherwise refuse to move forward with the engagement. In this climate of fear and unease, Poche began to spiral physically, mentally, and emotionally. That's one thing that is crazy about these contracts is that they tell them you can't quit, you can't walk away, or you're going to have to pay this much money per episode. We're going to look at it. We're going to look at the agreement. Like I said, it probably will be on a pre-recorded so that we can kind of point out the provisions that are glaringly wrong and just to go through the agreement. But yeah, they do often have provisions in there that you cannot quit the show or you're going to owe them so much money per episode. The thing about her is that her love story was not really aired. So why are they tripping on her like that? And then when y'all hear how much she was paid, not worth it. I would sue them too. Once filming Rat, Poche ended her relationship with Wall. In the following months, she made limited public remarks about her horrifying experience on the program, in response to which Delirium is trying to drive her into bankruptcy. Remember, she is in arbitration. This dispute is ripe for adjudication because Delirium has initiated arbitration against Poche for purportedly violating her unlawful non-disclosure agreement. Here we are with another non-disclosure agreement. Delirium is seeking an exorbitant $4 million from a young woman who earned a total of $8,000 for her appearances on the program. She was only paid $8,000 and they're suing her for $4 million. What do these provisions say? Poche contends that the agreement is itself illegal and unenforceable and brings this action to vindicate her legal rights under California law. I think she's gonna be right. Netflix is being sued left and right, y'all. Factual background. Renee Poche is a veterinarian who lives in Austin, Texas. Love is Blind is a non-scripted television program that has aired for 5 seasons on Netflix. And I like Love is Blind. I thought the connections were like real. I didn't know that they put them together. Like that kind of ruins the show for me. And I'm going to go downstairs and ruin it for my husband. The program encourages participants to develop a romantic connection with other participants without seeing each other face to face. Participants become acquainted through a wall. Couples meet face to face for the first time after becoming engaged, and they take a vacation together to Mexico and then return to their hometowns. Is it always Mexico? It probably always is Mexico. That's right. They return to their hometowns and integrate their lives and plan their wedding. In or around November 2021, a casting representative for Delirium reached out to Poche on Instagram, which is strange. Like, why are you finding people on Instagram? But whatever. Asking if she was interested in participating in the program, Poche was willing to consider the offer, and she went through the interview process and was selected approximately a month before filming started in or around April 2022. As part of the interview process, Poche filled out various documents, including an approximately 200-question compatibility questionnaire, wedding plans, and wedding guest list. Following her selection, Poche was flown to Los Angeles to join the cast of 15 men and 15 women. She was led to believe that participants were selected based on compatibility and marriage potential and screened with background checks and psychological exams. Prior to her departure from Texas, Poche signed a participant release and agreement. That's what's attached to this lawsuit that I want to break down. Poche signed the agreement online with no legal counsel and little understanding of the agreement's terms and scopes. They don't care about none of that. When they decide whether it was illegal or not, it's going to be looking at the terms, not whether she was represented by counsel or not. On her first night in Los Angeles, the program's production staff seized Poche's phones, passport, and driver's license. When not filming, Poche was locked in her hotel room, unable to leave without a cast wrangler accompanying her. She was expressly forbidden from interacting not only with other participants, but also with random hotel guests and staff. In some ways, this is a sentiment shared by many participants. Poche felt like a prisoner. It does sound prisonish. It does sound prisonish. Poche was paid a stipend totaling $1,000 per week for all of this. She made a total of $8,000. Why do they make so much money off of these shows and they're only paying them $1,000 per episode? Is that everyone, or is it just her because she was one that didn't get that much airtime? Like, why are they only, that's not enough money. Well, that's below minimum wage. Because I'm sure they have them working like at all hours. Here we go with another underpaid person in Los Angeles. And she's a veterinarian. So she was made to believe that the stipend could be clawed back and that she would be sued unless she agreed to all production demands. Ooh, $8,000. But I guess the suing is the terrifying part because they're suing her for $4 million. She was scared that they would take back the $8,000 and that she would be sued unless she agreed to all of production demands, even if they made her feel unsafe. One thing production was very clear about from the onset was their rigorous background check process. Production was insistent that all participants had been vetted and were marriage material. Poche was made to believe that the background check process would screen out those with significant red flags in their background and who might pose a physical danger to her and others. She's saying, nope, they didn't do that. Poche hit it off with an individual, Wall, who she later found out had lied about almost everything and who was, by any objective measure, far from marriage material. Wall, 6'5", former football player, was not only broke and jobless, but also homeless, violent, estranged from his parents, and actively addicted to amphetamines and alcohol. Given the background check process, there is little doubt that defendants had knowledge of these troubling issues. Why do you keep saying he's doing drugs and alcohol? Is she being mean or is this true? Wall regularly berated, poached, stole from the set or places they visited, and solicited others to buy painkillers and amphetamines for him on multiple nights. Wall did not go to sleep at all due to the abuse of the amphetamines. Wall was emotionally abusive on and off camera, lied malignantly, and heavily abused drugs and alcohol. So she went through the whole process with him and they just didn't air it. I remember hearing something about this, but geez, I didn't know all of this was going to come out in the lawsuit. Production was well aware of Wall's mental instability. One camera operator quit in Mexico after being physically threatened by Wall. In Houston, production staff warned Poche to ensure Wall had no access to firearms or other weapons because they were concerned he would hurt himself, her, or others. Why didn't y'all let her quit then? Poche was utterly terrified of Wall. Nonetheless, she was forced to spend long stretches of time alone with him, every minute of which she felt unsafe. Despite knowing about Wall's behavior and Poche's concern, defendants made it clear that Poche would subject herself to legal action if she were to discontinue her participation in the program or otherwise refuse to move forward with the engagement. Astonishingly, production even admonished her for not giving him a chance and encouraged her to continue filming. They didn't even air her portion. Her story was not aired. Her story was not aired. And they made her go through all that. That is emotional abuse, in my opinion. Can she qualify for intentional infliction? I don't know because I don't practice that kind of law, but that is emotional abuse. You didn't even air my portion of the show. And her safety really should have been their priority. And it wasn't. But remember, this is a complaint and it's all, shade and allegations. And she's shading. She's for sure shading. As a result of her participation in the program, Poche was placed in a dangerous situation, from which she had no clear escape. After shooting had wrapped, Poche was informed that her and Wall's relationship would be axed from the program. Yeah, so her part was not even aired. She went through all of that, and I feel bad for her. Although Poche was told that it was because production did not want her to have to relive her experience with Wall, that explanation seemed obviously false given the complete lack of concern for her well-being and safety throughout. Poche is informed and believed and based thereon alleges that Walls threatened to commit suicide if footage of him was aired. Okay. That's bad. This is really bad. And Poche made some limited public remarks about her distressing time on the program, including the terrifying experiences she had with Wall. Little did Poche know that Delirium and Netflix would try to ruin her for speaking out against unsafe working conditions she was forced to endure. On November 1, 2023, Delirium initiated arbitration against Poche, alleging 4 violations of the non-disclosure provisions of the unlawful and overreaching agreement, each carrying liquidated penalties of $1 million. Remember, we read a liquidation clause in the case on Tuesday for Kevin Hart. Their liquidation amount was $50,000. Basically, we don't know what the damages are going to be, but we are going to assume that $1 million should basically cover it. What you did is covered by $1 million. Is basically what they're saying. So they sued her for 4 breaches, and they were $1 million each. So they're suing her for $4 million altogether, which is freaking insane. The agreement contains numerous illegal and unenforceable provisions, which we are probably not going to read through all of these. Yeah, that's a lot. Of particular note is the release of liability. This overbought release purports to insulate defendants from liability of any conceivable kind. I'm sorry, y'all. We are not reading through all of that. She's basically said, it says, I, my heirs, next of kin, spousal equivalent, guardians, legal representatives, executors, basically anybody that knows her. How could she sign an agreement for anybody that knows her? Hereby unconditionally and irrevocably release and forever discharge each of the other participants in the program, the crew. So she has to discharge anything that Wall did her, the crew, the program, the producers, the network, so Netflix, any compliance company and other vendor, any television station or channel or cable or satellite network broadcasting or otherwise exhibiting the program, any sponsors, advertisers. They basically, anybody that works for the show, you cannot bring a claim for them arising out of this, arising out of the show. Ridiculous. No matter what, look how long the paragraph is. Like, that is relieving them of any liability ever. Maybe some good business attorneys, sure. To write that paragraph is wild. I would be confused. I'm not reading that whole thing. Let me know if y'all want a copy of it. No matter what subsequently happened on set, Poche purportedly preemptively gave up her right to pursue legal action on defendants' violation of the law. This type of preemptive blanket waiver of Poche's rights to seek redress against defendants violate public policy. I think she's going to be able to win on that. You can't just be like, you can never sue us ever for anything. Instead of writing it in that many words, they just should have said, you can never sue us ever for anything. That's literally what they should have wrote instead of wasting all of this paper. Okay? I feel bad for the person that had to type all of this out. They probably just copied it as a PDF, but geez Louise, that's intense. Pursuant to the California Government Code Section 12964.5, it is unlawful employment practice for an employer to exchange for a raise or bonus or as a condition of employment or continue employment to require the employee to sign a release of a claim or right under the Fair Employment and Housing Act. This includes requiring an individual to execute a statement that the individual does not possess any claim or injury against the employer or other covered entity, and includes the release of a right to file and pursue a civil action or complaint with or otherwise notify a state agency other than public prosecutor, law enforcement agency, or any court or other government entity. And in fact, any agreement or document in violation of the subdivision is contrary to public policy and shall be unenforceable. I think she's going to win on this. We need to look at some of the other Netflix lawsuits that have been settled or judgment has come on it. But yeah, just looking at that paragraph and the length and all of the words and all of the people that it included in the first 4 sentences, it included her mama, her daddy, her cousin, her auntie, her heirs, people that are not even born yet. Like it included so many people. That provision is going to be, it has to be found unenforceable. There's no way they can uphold this agreement. Like they're going to have to tone it down a lot to uphold this agreement. The statute's plain language indicates any agreement containing a preemptive release of claims under the FEHA is itself a violation of FEHA and renders such agreement unenforceable. Critically, the statute does not provide that the inclusion of an unlawful release renders the release provision unenforceable. Rather, it provides that the agreement itself is rendered unenforceable. It does say any agreement, the whole thing is unenforceable. She is right. As a result, in the arbitration proceedings, delirium in concert with Netflix is attempting to enforce an unenforceable agreement. And hopefully the arbitrators will see that too. Defendant's release also contravenes California unfair competition law. The UCL defines unfair competition to include any unlawful, unfair, or fraudulent business act or practice. Given its sweeping language, California courts have long held that the UCL applies to wrongful business conduct in whatever context such activity might occur. This includes violation existing under other laws. The UCL permits violation of other laws to be treated as unfair competition that is independently actionable. To wit, any employment practice that violates FEHA is independently actionable under UCL. The inclusion of the release also violates California Labor Code, which states no employer or agent, manager, superintendent, or officer shall require any employee or applicant for employment to agree in writing to any term or condition which is known by such employer or agent, manager, superintendent, officer, therefore to be prohibited by law. By forcing Poche to sign preemptive release of claims under FEHA, defendants have knowingly required the acceptance of a contractual provision expressly prohibited by law, a condition of employment. Basically, the fact that they even made her sign that is a violation of the labor code because they should know that that agreement is unenforceable. The release also runs afoul of California Civil Code. California Civil Code section 1668, all contracts which have for their object directly or indirectly to exempt anyone from responsibility of their own fraud or willful injury to the person or property of another, or a violation of the law, whether willful or negligent, are against public policy. It is now settled that in full. It is now settled and in full accord with the language of the statute that under 1668, a party cannot contract away liability for its fraudulent or intentional acts of or for its negligence violation. So they set her up with someone who was dangerous to her, forced her to continue to be with them. So she's saying that's a violation of the code. And yet the release purports to do just that. Poche was forced to release any and all claims, actions, damages, liabilities, losses, costs, and expenses of any kind as a condition of her employment. This includes, without limitation, infliction of emotional distress, products liability, breach of contract, breach of any statutory or any other duty of care under applicable laws, libel, slander, defamation, invasion of privacy, publicity, or personality misrepresentations. Let's see. Similarly, the confidentiality provisions of the agreement also violate California law. It says, I understand that any appearance that I may make on the program and in connection with the program, activities in which I may participate include without limitation. It is strictly for the purpose of participating in the program. Basically, you can't talk about what happened. And again, not even on social media. Look how long this paragraph is. You're telling me Someone's going to read this and understand this? I'm not even about to read it on my live stream. Absolutely not. The confidentiality clause violates California government code. This one, which states it is unlawful employment practice for an employer to exchange for a raise or a bonus, or as a condition, employment to continue requires the employee to sign a non-disparagement agreement or other document to the extent it has the purpose or effect of denying the employee the right to disclose information about unlawful acts in the workplace, which we have already talked about earlier. Further, a non-disparagement or other contractual provision that restricts an employee's ability to disclose information related to conditions of a workplace shall include in substantial form, which these are conditions because they're going to try to have another freaking season and they're going to subject people to the same conditions. Prevents you from discussing or any other conduct that you have reason to believe is unlawful. She should be able to talk about it, basically. Pursuant to the code, information about unlawful acts in a workplace include but not limited to information pertaining to harassment or discrimination or any other conduct that the employee has reasonable cause to believe is unlawful, like locking her in a room with someone who could harm her, right? Also, any provision in violation of the subsection is against public policy and unenforceable. So this one is just the provision that's unenforceable, unlike the one earlier that was the whole agreement. It is clear and unequivocal that any provision in violation of the subsection is unenforceable. The confidentiality clause violates California government code because it purports to prohibit Poche from disclosing information about unlawful acts in the workplace or information about other participants, namely Wall, who exhibited signs of extreme and dangerous mental instability. The release is also devoid of the required language set forth in the statute. Accordingly, the agreement plainly violates California law, prohibiting non-disparagement provisions for the purpose of the effect of denying the employee the right to disclose. Okay, let's see here. The confidentiality clause also violates California Civil Code, which provides, notwithstanding any other law, a provision in a contract or settlement agreement entered into on or after January 2019 that waives parties' right to testify in an administrative, legislative, or judicial proceeding concerning alleged criminal conduct and alleged sexual harassment on the part of any party, other party or contract of settlement agreement, and blah, blah, blah. The confidentiality clause impairs Poche's right to testify about her experiences, including numerous dangers faced by participants, specifically women. Any such testimony plainly relates to alleged criminal conduct or alleged sexual harassment on the part of the other party to the contract. Accordingly, the provision in that agreement that impair Poche's right to testify. She then goes to say the thing for arbitration is a violation as well. Let's read through that one because it's probably going to be similar to what's going on in the Kevin Hart one. Like we've talked about before on this channel, the mandatory arbitration clauses are often found not to be enforceable. This case is also in Los Angeles, just like the Kevin Hart one. So although we pointed out that there is an arbitration clause in the contract that he had his secretary sign, it's probably going to be found unenforceable. And that's why he didn't start off in arbitration, because he knows that it's unenforceable. Just like Diddy didn't start off in arbitration because he knew his was unenforceable. These celebrities know they put these things in these non-disclosures agreement and they are not enforceable. They know that. So let's see. Okay. The agreement is also enforceable to the extent it purports to waive Poche's statutory and constitutional right to file a lawsuit in a court to challenge the enforceability of agreements of arbitration provisions. The agreement prohibits Poche from challenging the enforcement of agreements arbitration provision. Why did they repeat that? Delirium and its counsel are aware that these provisions violate California public policy, which is precisely why the agreement purports to waive plaintiffs' right to assert public policy challenges to it. Poche seeks a declaration that these terms themselves violate public policies and are unenforceable. California law is clear, and litigants have a right to test the validity and enforceability of an arbitration clause before submitting to arbitration. Let's see here. In Sagron, the plaintiff filed a legal malpractice, blah, blah, blah. Let's see here. It is well established that a claimant may choose to disregard the arbitration provision of a contract. That's what we need right there for both the Kevin Hart case and this case. It is well established that a claimant may choose to disregard the arbitration provision of a contract and initiate a lawsuit, leaving it up to the other party to file a timely motion to compel arbitration. There is nothing to prevent one of the parties to a contractual arbitration provision from resorting initially to an action at law. So, like I said in Kevin Hart, Shakes is going to have to file a motion to compel the arbitration. We talked about that on Tuesday with the Kevin Hart case. Additionally, filing a civil complaint in Los Angeles Superior Court is constitutionally protected petitioning activity. Finally, Delirium is using the excessive liquidation. This is a very excessive liquidation clause. $1 million. Usually you see the one in Kevin Hart's where it's like 50,000, but $1 million is wild, okay? $1 million per breach on an $8,000 contract. They paid this girl $8,000 and they're suing her for $4 million. That's crazy, okay? And they didn't even air her portion of the episodes. Like, they didn't even air her. What makes you think she has this $4 million? As a bludgeon to the muzzle, Poche, destroy her life and make an example of her. A liquidation clause will generally be considered unreasonable and hence unenforceable under Code of Civil Procedure if it bears no reasonable relationship to the range of actual damages that the parties could have anticipated will flow from the breach. $1 million on an $8,000 contract, yeah, that's not reasonable. I don't know how much they're making on this show on Netflix, but her not even being aired talking about the case is probably not going to lose them $1 million, but it could, because I am thinking about not watching the show anymore, because how are you going to put that girl in danger, make her go through the entire 8 weeks, threaten her, and that she cannot get out of it, okay? And then not even air her portion of the episode, and then you don't want her to talk about how she was abused during the episode? Absolutely not. I don't even know this girl. Y'all know I'm usually skeptical about things, but Netflix and Delirium, this is out of control. Okay? Completely out of control. To assess liquidated damages of $1 million is a penalty against breaching party, not an estimate of a fair average compensation for any loss sustained by Delirium. As such, it should be declared null and void. Poche seeks a judicial declaration that she is entitled to challenge the agreement's arbitration provision in court without subjecting herself to liability to defendants, and further that any provision contrary to public policy or California law are illegal and unenforceable. And I forgot what provision it was that would be considered, I cannot breathe. That would be considered unenforceable, that the whole agreement would be, the one that says that she gives up claims to bring for violations of the law. The whole provision, the whole contract, in my opinion, should be unenforceable. Just that paragraph was ridiculous. Like, you wrote 2 pages on why she can't sue you? Oh yeah, it's going to be unenforceable. Let's go ahead and see what the peeps are saying. If you guys haven't already, please do hit the like button. You made it this far in. And if you haven't hit the like button, I don't know like what's going on. We are at 33 likes with 25 people watching live. So if you haven't hit the like button, please do. Y'all, I've been struggling through this live stream. I can't breathe. The least I deserve is a like. Okay? That's the least I deserve, is 1 like. Let's get it up to 40 likes if you haven't hit the like already. All right, let me go ahead and check what the comments are saying. Kimmy Walker says the Hershey case is wild, LOL. I haven't read it all the way, but I kind of scrolled through it. Tanya D says, I totally missed the poll today. I watched the Paula video you did though. Oh, thank you for watching it. Do you guys like it? I'm gonna have to play around with it. I'm not used to doing the pre-records right now, so I'm gonna have to get it together, okay? Let me know. Give me feedback. I will not have my feelings hurt. Maybe I'll post a feedback post in the membership tab so that it's not all public of y'all saying you need to do this. Jazzy G says they sued her for $4 million. Wow, and they only paid her $8,000. That's out of control. Kimmy Locker says I'd love to hear your thoughts on the contract breach, especially the provisions on divorce, some of which are wild to me. There's provisions on divorce? Okay. Yeah, we're going to have to do a breakdown on that. It might take me a while to get through that, but I think it'll be worth it. Kiardova82 says $8,000. Who's producing this show? Kevin Hart? The underpayment is wild this week. We got a bunch of non-disclosure agreements this week, and we got a bunch of people in Hollywood not paying people their money. No wonder why people in Hollywood have to have roommates. Henry Smith, hello, and welcome to the live stream. Says, Steph quit, but she can't. Right! But for all we know, they sued the staff too. For all we know, they sued the cameraman. Right. And they didn't even air her part. That's the part that's making me mad. Kimmy Locker says, I know we don't have time to dive into the agreement, but it explicitly says participants aren't employees. So I'm curious to hear your thoughts on that and how it could affect Poche's claim. So basically what they're going to try to argue is that their participants, i.e. independent contractors, they're going to lose. They're going to lose because there are certain things, and I don't know all of the elements, but ones that I do remember from law school, independent contractor it's a sliding scale, right? And it depends on the employer's control and some other things. But basically, Netflix and Delirium, they had the control. They made them stay in hotels. They couldn't talk to other people. They needed to be in LA to shoot the show. They were not shooting the show in their own apartment, right? They didn't bring their own tools and equipment in order to produce. Now, when you're talking about an independent contractor, you're looking more at someone like your gardener. Yes, they have to be and there's several factors. That's why I listed all of those things. Your gardener, they have to be at your house to complete the task, right? But most of the time, they're going to bring their own tools. They're going to bring a lawnmower. They're going to bring the people that they need to help them. The employer, if they have control over basically like I don't know the exact definition because y'all know I'm live streaming right now. But if they have control over what the employee or the person is doing, they're going to be deemed an employer, and that person is going to be an employee. You can tell them all you want to in the contract that they're not an employee, but if you treat them like an employee, they quack like an employee, and they act like a good employee, they are an employee and you are an employer. They're not going to win on that. They're not going to win on that claim that they're not employees. They are employees. You paid them and they don't have control over the way that they do the work. Heck, she tried to leave and you told her she couldn't leave. And then you have an agreement saying you cannot leave. Last time I checked, the man that cuts my grass every 2 weeks, I don't have a contract with him. He does not have to show up. In fact, he has not showed up sometimes. And I can't do anything about it because he's his own employer. I mean, I guess I could just, tell him never to come back and not pay him anymore, but he's his own employer. But if he was like my husband, and I told him, go use that particular lawnmower, and then I'll give you $3. Because you can underpay your husband. And when you do YouTube, you see how much Kevin Hart is paying his assistants. So I can pay my husband $3, right? But it's an employer-employee relationship. They have too much control over the way that the work is done. They're not going to be able to succeed on saying that they were not employers of the participants on the Netflix show. They're going to lose on that. But yes, I do want to break it down. It may take me a while because that's like a 20-page agreement. And as we just saw, that big old paragraph that's going to confuse the mess out of me. And they have a bunch of them. I don't know if I can do it, but I'm going to try for the BriHive, okay? Kimmy Locker says that's the first and last sentence of paragraph 5 on page 26 if you have the time and desire to check the verbiage. Okay, yeah, I'll check it out, but I'm pretty sure the same explanation that I just gave is going to apply. Devin Spicy, another member of the channel, hello and welcome into the live stream, saying, like when kids go in for surgery, hospitals make you sign a release that if something goes wrong, hospital cannot be held accountable. Nope, we're going to war if you mess up. They always do that. That's just like when you go skydiving and they'd be like, you assume the risk. Okay, but not really. You have to sign those things to do the activity. There are ways to get around there. And the parachute doesn't work and we can't blame you. Yes, you can. I say sign the waiver. Sign the waivers. If you want to do an activity, sign the waiver, because no matter how much they tell you that they are not liable, I guarantee they are going to find a way. You're going to find you a personal injury lawyer that is going, not Tom Girardi now, okay? Don't find Tom Girardi because you might not get your money. You might win, but you might not get your money. You will find you a personal injury lawyer that is going to find a way that whoever told you that they were not liable and made you sign a waiver, they're going to find a way that they're going to find a way that they're liable. Period. There's no way around it. It's no way around it. Very rarely do these agreements succeed in court. Especially now, I commend the lawyer that drafted that paragraph, okay? They probably made it clad iron. They probably made it strong, okay? It's just not going to be enforceable in court. It's too strong. There's no loopholes. There has to be. You can't just lock people into contracts like that. I get wanting to be on TV and wanting the fame and wanting the Instagram dollars because now you can, sell things to your community. But to tell her grandma, her daddy, her cousin over there on the other side of the world, her ex best friend cannot sue them for things that they do to her. Yeah, that's not going to fly. It's not going to fly. It was too much. It was thorough. It was very thorough, but too much. Too much. They're not going to succeed on that. Okay, let me see. All right. Harry Smith says, I think the 4 million is an FU. Oh, yeah, it is. Like, I see the ones that say 50,000. Normally, when I read these show complaints, it's 50,000 per episode or 50,000 per breach. They said $1 million per breach. She could just say, I don't like Wall. Breach. Wall was mean to me. Breach. $1 million. Cha-ching, cha-ching, cha-ching. That's all they're doing. That is an FU, and it's basically trying to scare her. And luckily, she was strong enough to get an attorney and bring it to court. Kimmy Locker says there's multiple provisions on divorce, one of which is an agreement not to file or initiate any proceedings until the last episode airs or 11 months after the wedding date, whichever is later. I believe that. I haven't read it yet, but I definitely believe that. And it makes sense because they have to sell the show that this is a love show and these people are in love. Are you really in love if you get a divorce in 2 weeks? Probably not. But a lot of them, they get married in these marriage shows and then they separate after 2 weeks. So what's the difference? What's the difference? But that is interesting. Jazzy G says, oh, I'm curious on the divorce too. I've seen rumors that they can divorce before the after the altar. Yeah. So Kimmy said either 11 months or after the last day that the air shows, whichever one is latter, I think she put. I can't remember. But yeah, okay, I'll do a pre-recorded video on the contract. Tanya D says, you definitely deserve all the likes for streaming while sick. I am struggling. Like, y'all don't understand. One nostril is clogged. And just, I don't know if y'all care, but it's like one nostril is clogged. I keep like making all these weird grunting noises. I don't know if you can hear it, but thank you. I appreciate y'all from being here. This is still a good live stream, although I can't breathe. And although No one else hit the like button, but that's all right. We good. We are good. If you haven't already, please do hit the like button. It does help us out. And y'all hear me struggling on this live stream, bringing the content for y'all. We are being serious in 2024, okay? Deaf and Spicy says, Bree, I'm with you. I tried to offer to pay my husband to do the lawn. He doesn't go over, it doesn't go over well. So I put up with the lawn guy being unpredictable. Right. My husband don't even want to buy a lawnmower. I'm like, we're going to spend more on the lawnmower and guy after so much time because, just buy the lawnmower. But the thing is that we only have like a little patch of grass and that we're probably going to get rid of. So maybe we don't need a lawnmower, but I don't know. Oh my gosh, y'all. This was a lovely, lovely live stream. Thank you for letting me know what y'all thought about the case. I think Netflix is going, or I guess it's not even really Netflix, it's Delirium. They're going to be running away with their tail between their legs because a lot of these provisions are just not going to fly. While I do commend the lawyers for drafting such crazy and, solid provisions, you got to know that some of this stuff is against public policy. But a lot of stuff in contracts is, I hate to say it, to scare people. A lot of stuff is boilerplate. A lot of things don't apply. You just write what you think applies, and then people can always sue you. You cannot tell someone they can't sue you. You cannot do that, okay? You can agree to mediation, you can agree to arbitration, but okay, when you cut my leg off, I don't want to mediate anymore. You're entering into those agreements on the best case scenario situation. But when you exceed the expectations of the contract, you cannot expect someone to be okay with just going with these terms. And then there's also a thing of bargaining power. These are big production companies. They have all the money. They have all the say. They're telling you, if you leave, you're going to pay $1 million. I don't have $1 million. I'm a veterinarian. I'm a young girl. Why would you think I have $1 million? So she's going to be afraid to leave. She's going to, they have this power, bargaining power over her. They wrote the contract. She didn't get to make edits. That's another way to find that the contract is unenforceable because she didn't get to give her feedback on it and have her lawyer. Well, she didn't have a lawyer, but if her lawyer would have reviewed it and changed it and did all of the things, right? But they didn't. They did it. And now she's stuck with it. But a court will see that like, oh, were these terms negotiable? No, they weren't negotiable. If she would have said, change the 1 million to the 50,000, you think she would have been on the show? No. Okay. So, and 50,000 is even too much for the 8,000. But I guess she was getting paid a better pay rate than Kevin Hart's assistant because it was $1,000 per week. So if she did 52 weeks, I feel like they should pay them even after the episodes air. But this is common with these reality type shows where they just pay them for the actual episode, but they don't pay them like any royalties. It's a bad setup. But yeah, I'll probably, like I said, do some more of the can I get rid of my banners? Okay, that one's gone. Okay. Excuse me, y'all. So I'll probably do a deeper dive on the actual contract and react to that and what I think about the provisions for y'all next. Maybe not next week, maybe in 2 weeks, because I have a training over the weekend and I don't know if I'm gonna have time to record before next week, but I'll do that. I'll also cover the chocolate case. Maybe we can get it onto a live stream because I think it will be fun to do on a live stream. But we'll just see where the week takes us. Thank you everyone for coming live. If you haven't already, or on the replay, if you haven't already, please do hit the like button. It really does help out the channel. We have big goals for the channel. You're going to see me doing some different things on the live stream moving forward. So just bear with me, y'all, as we try to grow the channel and get more people in our community and more people to chat with us, laugh with us, and have fun with us. Get some little slogan going. Feel free to drop your opinions. I think I'm gonna have a vote in the members column for my some slogans to put out for us. So we'll do that. Yeah, I'll do it in the membership. And then we are for sure going to have a freaking members live stream this month. Not this weekend because I have a training. Maybe next weekend, maybe the weekend after that. So I'll do a poll in the members tab to see when everybody is most available to do a members live stream. So if you guys would like to join me live on the video camera, make sure that you become a member so that we can invite you up to the stage. I hope everyone has a wonderful weekend. Like I said, I will be in training, so I am not going to be having that much fun. But I hope I get a little bit of rest, and I hope you get some rest too. And I will see y'all all